All right, as we wait for the proceedings to begin, you notice it is a very small courtroom. We were led to believe that the defendants would actually be in court. We understand now that they will be appearing, as they have done before, via Zoom. Whether that changes, because the defense has filed a motion to allow the defendants to appear in person. We'll see if that changes today, but at this point, we're being told that the defendants are appearing via Zoom. There's no media allowed into this courtroom, too. There's a media overflow room across the hallway from this courtroom in the Glynn County Courthouse. Limited family member participation as well. The COVID restrictions are still in place. You see that the attorneys are not wearing masks, but the court attendees, the marshals are wearing masks. And now it looks like the defendants are coming into the courtroom, as we were told earlier. That appears to be a much thinner Travis McMichael sitting down at the defendant table and donning his mask. And so very interesting. The defendants will appears to be in the courtroom while the proceedings begin. And that, I would suspect, is the delay. The judge is on the bench and they're just waiting for the defendants to be brought in. Judge Doug Chanko and Michelle Thomas are with me as we watch this. And Michelle, boy, it looks like Travis has lost some weight being incarcerated.
It does. You can see that it's certainly taken its toll on the defendants there. The stress of being incarcerated for all of this time certainly will have an impact. And this is the first time I understand that they have been able to come into the courtroom and be involved with each other. I mean, these are significant charges, and the bottom line is that justice needs to prevail. The justice system needs to go forward, and they have to accept the process and whatever the court's rulings are from the motions today, and then ultimately whatever this jury decides.
And Doug, it is important to have the defendant in court because, I mean, you see it right here, the ability to communicate with your attorney during these very pivotal arguments. Defendants can add to their own defense, add color, add information. And via Zoom, it just isn't, it doesn't work the same way, does it?
No, not at all. Zoom is great for what it is, but it's not the same as being there live and in the courtroom. It happens fast. There are many times where there could be a delay or an issue of being able to communicate that would be lost if you weren't there in the room. They absolutely should be there. It's the best of all options.
Okay, there's William Roddy Bryant shaking hands with his attorney, Kevin Goff, the last to walk into the courtroom. Again, the judge is going to be entertaining a series of motions over 2 days. There's a lot at stake. Let's listen in. Here we go.
The court issued ultimately an amended notice of hearing for today's date and tomorrow's date. The idea being to set aside 2 days just in case we needed 2 days. I'm not suggesting everybody fill all of that time, but just in case we needed 2 days to hear matters. The notice of hearing set forth 12 matters the court intended to hear today. There are a couple other motions that are out there which we can touch on at some point during the proceedings just to see whether or not we need to have evidentiary hearings on those matters or whether they can be addressed pre-trial. When I say that, there is a trial notice that the court has issued to begin jury selection October 18th, and there may be some time to hear some matters obviously at that once jury selection has been completed and before the trial of the case. A couple matters before we get started. First, with microphones, what I've been told here in Glynn County is the gooseneck mics go into the system. There are not gooseneck mics over on the council table to my right. I can probably hear you. There is a mic that goes into the system at the podium that you can use. Let's just sort of start working through it and see whether or not that is or is not an issue. If anybody has a problem hearing somebody that's not on the mic, please let me know and we'll just go ahead and get that addressed. Also, I just want to make sure with cell phones, it's my understanding the policy here in Glynn County is that if you have a cell phone, you can't take it out in the courtroom. I'm going to have everybody in the courtroom adhere to that policy. Before we get into the actual motions themselves, let me just go ahead and get announcements. Anything preliminary from the state?
Nothing from the state, Your Honor.
From Travis?
No, Your Honor, I'm just looking for some direction of where you want to begin. And if we can help inform you a little bit about what we're doing today, and we're happy to do that.
Yeah. From Gregory, take it away.
No issues preliminarily, except as if you were to do what Mr. Sheffield suggested, we have some matters that we've already agreed upon, and that may help you understand what's going to be litigated today. Thank you.
I think it would be helpful to kind of have like a calendar call for motions this morning to figure out the exact order we're going in and make announcements.
Yep. So I have, I've got 12 matters on the notice of hearing. One of them, I understand, has been withdrawn, and let's just go ahead and address that right out. There was a immunity motion filed by Mr. Bryan that was withdrawn on May 5th, formally through a notice to the court, so that matter's not before the court.
That's correct.
So the remaining items I have then are the 11 on the notice of hearing. If some matters have been resolved, let's go ahead and get that on the record and then order what remains. So,
Your Honor, number 2, motion to adopt co-defendant's objections. The state filed a very nice response and it persuaded me, so we're withdrawing that motion.
Your Honor, with respect to...
hold on just a second. So that is the motion to adopt co-defendant's objections filed December 30th that has been withdrawn. And that's withdrawn on behalf of both Travis McMichael and Greg McMichael.
That's correct, Your Honor.
And also, we're also withdrawing the motion we joined on.
All right. Any other motions being withdrawn?
It is my understanding, Your Honor, after some discussions with the state, that number 4, the state's notice of intent to introduce evidence of other acts, 404B, against defendant Greg McMichael, has been agreed upon that that issue would not be introduced in the defendant's case in chief. Oh, excuse me, I misspoke. That information the state would not intend to introduce in their case in chief. However, we have been told that in the event that the state believes the defendant has opened the door, and we can clarify that later on in perhaps some stipulations about what that would look like, then the state would be asking for a 404B hearing at that point with respect to possibilities of it not being a 404, but instead being impeachment. And so, and I wanted to make clear to the court, I am not stipulating to the authenticity or the foundation of the Facebook, the number 1 and number 2 404B acts that the state has noted against Greg McMichael. There are, it's my position, there are some significant issues with respect to that, but those don't need to be heard today because this may never come to fruition.
While I appreciate Ms. Hogue speaking for me, I was actually going to address the court because I do need to address the court on that issue fully. And if the court would like me to do that now, I'd be more than happy to.
Let's wait. Let's address it as a matter that would be then before the court. I mean, based on this, I think I understand what's going on. The idea would be, depending on whatever the defense may be, that conversation could go in a different direction, or that argument, I should say, would go in a different direction. This is a matter that I would either, for today, if I can get a stipulation between the parties, great. If not, I'd like to get a little bit more information on where we're going and how it's going to go, because once we get into the trial of this matter, I would prefer not to stop and to address this issue. So let's flesh it out a little bit further as we move through the motions.
Very good. Thank you.
Let me do, it's easier for me just to keep it in order.
Sure.
From the state, I understand no preliminary matters, no announcements then on the specific motions.
No, Your Honor, just that I want to let the court know we do have Mr. John Fowler from the Attorney General's office here to address the disqualification issue and also the motion to strike the appointment issue, which I'm assuming the court may want to take up first based on the nature of those motions. And so we wanted to let you know that. We also filed 2 motions to quash Defendant Bryan's subpoenas for both Mr. Jesse Evans and for DA pro tempore Flynn Brody.
So I have both of those. All right.
And just to make the court aware, we have 8 witnesses we intend to call on the 404B and the mental health issue that we've raised, whether the state has moved to oppose any evidence on that. Thank you.
All right. Anything further than?
Your Honor, the number 1 motion is the Omnibus Motion, which technically addresses the statements of the defendant. Frankly, Ms. Burton, we had planned for her to handle that. Also, looking over the pleadings, I think one can argue the notice issues, but I believe, and I'm not sure where the state stands, that the admissibility of Mr. Bryan's statements to the GBI as opposed to the Wayne County Police Department, those are probably better addressed closer to trial.
Your Honor, having spoken with Mr. Goff yesterday, I brought to his attention that he had failed to particularize any sort of Jackson v. Deno motion, and I pointed out that there were no custodial statements. Everyone went home after they spoke with the police department. However, Mr. Goff then filed at 4:50 last night an amended omnibus motion seeking to suppress his client's statement to GBI agent Seacrest on May 11th of 2020. Mr. Bryan was not in custody, and Mr. Goff accompanied him to that particular interview. At this time, the state could go forward tomorrow with Agent Seacrest if you so wish to hear this motion. The state's response, of course, is that it's untimely. Any sort of motion to suppress had to have been filed by December 30th per your scheduling order, but we understand that you may still wish to hear it. Of course, we only got notice of it yesterday. We leave it to the discretion of the court whether to hear it tomorrow and or near to trial.
And I understand your concern. We would be ready to address. I will be ready if directed. We can do it tomorrow if the court prefers. But to be fair, we filed a motion at the beginning of this case. I don't recall the state filing a response to it concerning the circumstances under which those statements were made. And we specifically referenced in there the issue as to the voluntariness of those statements under the state statute. I don't know how the state could claim that they're prejudiced or unaware that the voluntariness of those statements is an issue. That doesn't matter whether he's in custody or not if they're involuntary. That's a pretty high standard when you're not in custody, but that's not the sole question. It's not just an issue of custody. I would rather that Ms. Burton handle the entirety of the omnibus motion. I promised her that she could. She can't do it tomorrow, but I'm certainly capable of having that hearing tomorrow if the court directs. And I will do as directed by the court.
So it's a one-witness Jackson Deno?
Yes, Judge, it is.
Yes.
Trial's not until October. The state's claiming that the specificity is lacking. I think we now know what it's about. Let me think it through. Let's see how the timing goes. If we get into tomorrow, I may hear it tomorrow then. That just gives the state enough time to work through whatever the issue may be, since it's a second witness and we know what the statement is. So I will put that down at the bottom of the list as far as priorities I'm reaching today, and I'll come back to it to make a decision on what I consider. My position on Jackson Deno, I think we just need to hear it now when the issue's been raised. So at some point before trial, it's going to be heard. It's just a question of when.
Yes, Judge.
All right. So, what I would like to do is the motion to disqualify, the court does want to address up front. As far as the remaining matters, we can probably then work into the 404B because we'll have the witnesses. And then get into the state's notice, and then just start working through some of these other matters, unless anybody has another proposal. That's how the court intends to proceed.
Sounds great, Your Honor.
All right. All right. First matter up then, I have, it's number 9 on the amended notice of hearing. The defendant, Mr. Bryan, filed a motion to disqualify the prosecutor and for other relief. That was on March 1st of this year. The state's response. Well, let's see. There was also a motion to compel the lawful appointment of the district attorney. There's a second motion to strike the illegal appointment of the district attorney. I think those are all out. Just name all those because they strike me as all related. Mr. Goff, your motion.
Your Honor, with respect to the motion, the second motion to strike the legal appointment, the first motion the court's already ruled on. With respect to the second motion to strike the legal appointment, we're going to stand on the argument that is set forth in our motion. The legal issues we have addressed to this court before, for the most part, and the court has already entered a ruling. I think the court was incorrect, and we certainly can address that if the court wants. But I'm prepared to stand on the motion that is filed.
That's fine, Your Honor. The state will also stand on its response, once again, specifically citing to State v. Mantooth, 337, Georgia Appeals, 698, the 2016 case, that of course holds that a criminal defendant has no standing to object to a prosecuting attorney's voluntary recusal and or the AG's appointment of a substitute district attorney pro tempore. And so we ask that you deny his motion. Thank you.
I've got the motion to compel the lawful appointment of another district attorney.
Your Honor, I believe that was done. Well, an appointment was done. We challenged that appointment, but we made the original motion. The court notified the Attorney General. An appointment was made. That's subject to the second motion to strike. I don't think there's anything to be heard on.
Your Honor, that's correct. The state filed on February 5th, 2021. It is part of the record, the notice of appointment. At that time, it provided the Georgia Department of the Georgia Department of Law's administrative order by the Attorney General appointing District Attorney pro tempore Flynn Brody of the Cobb County District Attorney's Office. In addition, the state provided notice that Assistant District Attorney pro tempores would be, at that time, Mr. Jesse Evans, myself, Linda Dunikoski, and Mr. Norman Barnett. At this time, we also make the announcement to the court that Ms. Larissa Oliveri, who is seated next to me, is also an Assistant District Attorney pro tempore in this case. Thank you.
And just so we track all this, the court had issued sua sponte an order after the motion had been filed directing an appointment, and that's part of the record. All right, and that leaves on this issue the first motion to disqualify the prosecutor and for other relief.
Well, before we get to the substance of that motion, there are multiple Brady requests and 2 motions to quash subpoenas in the case. I think it would be helpful to address those before we started presenting evidence. But obviously, the court has to make that determination.
Let's go ahead and address those. I'll call them preliminary matters, but let's go ahead and address the motions to quash and evidentiary issues associated with this motion.
Yes, Judge. And would you prefer I stand in my place or stand at the podium?
Wherever you're most comfortable.
All right, as long as the court can hear me. First off, Mr. Goff served Mr. Jesse Evans with a subpoena to come and testify. This was in regard to two issues, both of which do not qualify prima facie, on their face, for a reason to disqualify the Cobb County District Attorney's Office from this particular case. He, prior to his resignation, which took place April 26th, he is still employed by our office, giving us notice, and his last day will be May 28th of this year. However, having resigned, I then was appointed to the lead counsel. Having been former lead counsel, it's inappropriate, number one, to put him on the stand in an effort to disqualify the very office that he was working for. In addition, the two issues are communication and or contact that he had with Greg McMichael 5 years ago during the Justin Ross Harris hot car death that took place here due to the change in venue out of Cobb County, and the statements he made to a magistrate judge who wanted to know in Cobb County, how is it that we were able to convene a grand jury down here in Glen in order to indict this case, but we're not doing the same procedure up in Cobb County. Mr. Evans, in that transcript, which the state has no problem having the court look at that transcript, Mr. Evans said what he said in a transcript, gave an explanation, and it's based on the Supreme Court of Georgia's guidance on convening grand juries that were issued. So at this time, the state wishes for you to quash the motion or quash the subpoena for Mr. Evans to come in here and testify in an effort to have him explain the inner workings of the district attorney's office's decision to get this particular case indicted during the COVID pandemic per the direction of the Supreme Court of Georgia, and also to have him come in and explain the contact he may or may not have, that he may or may not remember from over 5 years ago during a trial down here in Glen. Thank you, Your Honor. And that's with regard to Mr. Evans.
Mr. Goff on that issue.
Your Honor, I'm going to start by the allegation is made in the motion, although kindly not repeated today, that the defense and defense counsel has been unprofessional in filing this motion. The implication being that there's no good faith basis for pursuing it. And I think it's appropriate to point out that this is not a fishing expedition. It is a motion based on articulable grounds. Particularly in this case, prejudicial comments were spread literally around the world, practically boasting of the improper influence of people associated with the victims in this case over the prosecution of this matter. That is not to say those statements are true. But when those statements are put out there, it raises questions as to the appearance of impropriety, and it's my duty as defense counsel for Mr. Bryan to explore those. Because more particularly, we have had statements put out there urging potential jurors to ignore the citizen arrest law because it is unjust. Statements about getting quote unquote justice by quote unquote any means necessary.
At this point, Your Honor, I'm sorry, I'm going to object. None of this, I don't know what Mr. Goff is talking about at this point. This first motion to disqualify the prosecutor and for other relief cites to absolutely nothing that he's talking about. And by the way, what he's talking about is well beyond the control of the state of Georgia.
It doesn't matter. The question is not whether the actions of independent third parties are beyond the control of the state of Georgia. The question is whether the public statements and actions of independent third parties have reasonably created the appearance of impropriety in the Cobb County District Attorney's Office, and either the past or the present DA. And hang it, we're focused on the present DA right now. But my point, Your Honor, is when the state comes in and says this is a mere fishing expedition, that there's nothing to be concerned about, I think the court has to look at that in the context of other people have pretty much told the world that they're controlling who prosecutes this case. And that alone, even though the state has no control over it, requires that I pursue that motion, and I do so in good faith. And I think that Your Honor, who is the impartial arbiter in this case, I think Your Honor has a duty to explore in sua sponte whether there's
any appearance of impropriety in this matter. We have, and I'm going to finish, and I'm going to make that proper, that we have the representatives of the victim putting out in social media that the appointment of Joyette Holmes in the Cobb County DA's office was quote unquote a huge win for the Arbery family. Another person associated with that boasting about spending $500,000 to have these men quote unquote held accountable, boasting that they quote unquote devised a strategy to get these men. Now, you combine those facts, which I don't think the state disputes, they dispute they have control over them, okay? But you combine that with the allegations in the motion, which are talking about a campaign website specifically attacking the prior district attorney and her office for having a conflict in this case, and for making other statements about this case, and at the same time openly campaigning for the current president, I think the current president of the United States, Joseph Biden, and Kamala Harris, and the entire ticket, all these just outrageously partisan statements, and interspersing my client's case in the middle of all of it. Now, why do we need Brady responses? Why do we need testimony? Because the state has stonewalled this entire time, and what we find on social media doesn't mean it's all that's there. What videos and other statements that we find, I would respectfully submit, we believe we found the tip of the iceberg. That there's all kinds of stuff going on in Cobb County that we have no way of verifying on our own. All kinds of things are happening up at the Capitol. The only way that we can get to that information, and I think the information that's out there certainly provides a good faith basis to go through. The only way to access that information is to require the district attorney's office to produce the evidence that is within their control, within the meaning of Brady v. Maryland, and putting up the only people that actually are likely to have that knowledge. I mean, let's be clear. The odds that Linda Dunikowski, the state's prosecutor, now head prosecutor handling this case, that she was necessarily involved in conversations between Flynn Brody and the President of the United States? Maybe, but I'm guessing not. Any of those kinds of, if there were communications between Lee Merritt and Sean King or Ben Crump and state officials, it is unlikely that Ms. Dunikowski would have knowledge of that. I'm doubtful that Mr. Evans would have knowledge of that. The only people within those offices likely to have knowledge of such sensitive things would be the current elected district attorney and the former district attorney. Obviously, the former district attorney, having stepped aside, I can't disqualify somebody who's already out of the case. But still, the state has an obligation not to simply say, well, you found a website, you found a town hall video, you found a bunch of social media posts that are boss made, but that doesn't provide any reason to question what's been going on here, and we don't have to disclose information that we have possession or custody of control over that would suggest that our office has developed an interest in this case. It's not simply a conflict question with Mr. McMichael. Does Flynn Brody and the Cobb County District Attorney's Office, have they developed a personal interest in this case? Whatever the court decides about Greg McMichael and his relationship in the Brunswick District Attorney's Office to the Cobb County DA's office, whatever the court decides, Mr. Brody, having inserted this case into his campaign for district attorney multiple times, and once he's done that, you can't come back and say, I was just kidding. It's just, as the district attorney says, campaign rhetoric. And we're certainly entitled to know if there's more to this than we have been able to discover. And that's what the Brady request is for. It's one thing to say that they don't have the information, that it's beyond their control. It's a different matter to say it doesn't exist, and it's still a third, entirely different matter to say it's not relevant. And if there's any question, as I stated in my motion, I think the appropriate thing to do would be for the state to submit all of the information that's subject to that they have possession, custody, or control over access to, including the privately maintained emails, phone calls, etc. All of that information to be submitted to this court in camera, and then this court can make an in-camera inspection of all that information and decide what we're entitled to under Brady v. Maryland, because ultimately, that is the remedy. It's for the court to conduct the inspection.
And that's a way of addressing this in this case. I'm not trying to embarrass Flynn Brody or Joyette Holmes or Jesse Evans or anybody else. I'm just doing my job for my client. If the court reviews the information we've requested and the court says that there's nothing there, it'll be placed under seal in the file and it can be addressed on appeal.
Okay. The topic we were on was the motion to quash. The former lead counsel in this case, Jesse Evans, having heard the arguments of counsel, the motion to quash the subpoena of Jesse Evans is granted. The court's not going to compel the former lead prosecutor to testify in this case. The standard for doing so has not been satisfied by the defendant and by the defendant's counsel's own words. He probably wouldn't be the witness that would be appropriate before the court anyway.
And therefore, Your Honor, we now move to the state's motion to quash the subpoena and brief in support of that I filed on May 10th for the subpoena given to District Attorney Pro Tempore Flynn Brody. That required his attendance. He, of course, is here, would be anyways. But for him to testify would be inappropriate. Once again, he is the elected official of Cobb County. He is the manager of this prosecution and this prosecution team. And for him to have to testify or bring with him the defendant's request for all electronic communication from 2011 to present, if any, between defendant Brian's co-defendant, Greg McMichael, and anyone within the Cobb County District Attorney's Office is incredibly burdensome in this matter. Right now, the people who probably or may have had any electronic communication with Greg McMichael have left the Cobb County District Attorney's Office. We have no access, meaning the prosecution team, to their closed email accounts. It would take the Cobb County IT department to see if they could even get this information, and I don't even know what kind of search they would be able to do to discover this. I will state in my place that I am the appellate attorney on the Justin Ross Harris case, and thus having reviewed the file, found no communications in that particular file between anyone at the Cobb County District Attorney's Office and Greg McMichael. Therefore, to have Mr. Brody, who was not the DA during that period of time, having been elected last November and taken office this January of 2021, to testify to matters he has no knowledge of, or to bring into court matters that he has no knowledge of, and by the way, is incapable of bringing or presenting at this time, we ask that you quash that subpoena for the Greg McMichael communications, as it is burdensome. In addition, once again, the defense has failed to breach the threshold of anything that would disqualify Flynn Brody from being the district attorney pro tempore due to any campaign rhetoric that may or may not have been on his website. The two things defendant Brian cites to, are a post that is obviously erroneous on his website, saying that Joyette Holmes had a relationship with Greg McMichael. Obviously, it was Jesse Evans who had a minor business relationship with Greg McMichael 5 years ago during the Justin Ross Harris case. So while it was on a web page, it was erroneous. That does not breach any sort of threshold for disqualification due to an interest in this case. Therefore, to put Mr. Brody on the stand to ask him about his campaign and everything that he did, because of course politicians advocate, I should be the better candidate, I'm the better DA, they are of course going to attack their opponent by pointing out how they're a better candidate. We also have a YouTube video that of course is not in possession of the district attorney's office. And therefore, given that those are the only things Mr. Bryan has proposed, the state will state in its place, we understand our Brady obligations. We understand them fully. If there was a reason for us to be disqualified, we would go ahead and provide that to the court and to Mr. Bryan. At this time, there's no reason to disqualify Flynn Brody or the Cobb County District Attorney's Office as the district attorney pro tempore, and Mr. Bryan has not even breached the threshold or made a prima facie case with any of this that would call for disqualification. Therefore, we ask for you to quash the subpoena. Thank you.
Your Honor, I assume their motion to quash the subpoena encompasses the subpoena duces T condition to Mr. Ross.
Sounds like that's what she was arguing.
I think so. Your Honor, we're entitled to have any information that would reasonably call into question whether the Cobb County District Attorney's Office should be handling this case. If there's any question as to whether Mr. Roddy has developed a personal interest in this case, whether when he was a candidate or subsequently, it is appropriate. It's also appropriate to inquire as to whether there's any basis to believe that there's a relationship between the Cobb County District Attorney's Office and Mr. McMichael, directly or indirectly through the Brunswick District Attorney's Office. Now, I understand the difficulty of the state responding to the multiple Brady requests and to the subpoena, but let's be clear. These requests have been filed from the outset of this case. The state has had ample time to address these issues. Now, the state wants to present this as it's only a matter of Greg McMichael. Greg McMichael is related to a lot of other people in the Brunswick DA's office that have ties to the Cobb County DA's office. They're referenced in the exhibits that will be tendered, including another assistant from the office that they hired in the sex crimes division. And around the same time, suddenly Mr. Brown was there are allegations thrown about that he somehow was being investigated for sex crimes. Maybe it's just a coincidence. I don't know. But the only way that we can really get to the bottom of it is for them to comply with the Brady motions in the manner I previously discussed with respect to the previous motion, or in response to the subpoena. I would note, Your Honor, they're presenting this as if it's just one case, and it's not. The Brunswick District Attorney's Office was involved with the Cobb County District Attorney's Office in the prosecution of DeMarquise Elkins, a Brunswick case that was transferred to Marietta for Cobb County. I know that because I was lead counsel in that case as circuit public defender. And I know that Mr. McMichael was involved in the case. And I'm almost certain that he was issued a Cobb County District Attorney's Office identification badge at that time. For all we know, that identification badge is still valid as we speak here today. And I don't doubt that Ms. Dunkowski may be unaware of it, but the state is the state. Any knowledge of anybody in their office is attributable to them. And to say that just because someone left the office, that there's no longer any connections, it's wrong, Your Honor. They can claim that there's no appearance of impropriety, but Your Honor has a duty to uphold the integrity of this process. And when you see articles being published in the Atlanta Journal-Constitution and other places where people who are completely uninvolved in this case, legal scholars, but completely uninvolved in this case, openly question from day one the tie between the Brunswick office and the Cobb County office, it does raise the suggestion that the only reason the Cobb County office has this case is because it was accepted to the Arbery family, and we're entitled to know what assurances or promises were made behind closed doors that suddenly made that okay. They need to respond to the Brady motions. They need to respond to the subpoena ducis tecum. If they want to submit documents responsive to the subpoena ducis tecum to the court for an in-camera inspection, we're okay with that too. But if they're not going to provide any of that information, the only way that we can get to it is through witness testimony. And then they don't want to allow us to call the only witnesses who might actually have personal knowledge of the relevant facts and circumstances. In other words, we can file any motion we like, we just can't develop or present or have the court hear the evidence on it. And I believe that this court is well aware of the unusual nature of this case. I've never been involved in a case before where we've had 3 separate laws adopted since this case started, which are almost directly attributable, or if not directed to this case. We have a new citizen arrest statute. We have a hate crime statute. And now we have a change of venue law that seems unlikely to apply to very many, if any other cases in the state of Georgia, other than this one. So we have all these statements from all these elected officials about this case and about these cases around the country. And to say, given Mr. Roddy's actions as a candidate and given the relationship, these are important issues. And while everybody knows that Greg McMichael had dealings with the Cobb County DA's office, unless we can get witness testimony or production of evidence, how do we go beyond the statements thrown out to the AJC and other places that they don't feel there's a conflict? We have the right to contest those statements. And that's what we're asking the court to allow us to do today. And if we can't present witness testimony from the only people associated with the prosecution who are likely to have that evidence, then we're going to go proceed with this motion with one hand tied behind our backs. And that's not due process.
Okay. Mr. Cobb, the way this motion has been presented to the court today, the court does have concerns that this just is, in fact, the hearing today would simply be used as a discovery. That this is just looking for information. I was trying to track the variety of different connections that you were trying to make in the case. I'm granting part, denying part, the motion to quash. It is all granted except within 10 days of today's date, the state is to provide to the court in camera any correspondence between the Cobb County District Attorney's Office and Gregory McMichael. That is a starting point for the court. Depending on what is produced, I may ask that additional information be provided by the parties, but that's what I want to say. The balance of the motion is granted.
Yes, Your Honor, thank you.
On arguments with respect to the motion itself, beyond what I've already heard, is there any additional argument then from the defense to your motion?
Technically, Your Honor, we would need to present our evidence. There's not a lot of surprise in that. But technically, I don't know that we have made the exhibits part of the record. We're going to tender at this time exhibits 1, 2, and 3, and 4. Your Honor, exhibit 1.
Let's be very, I've been requested to make sure that we're very clear about how we're going to be marking and identifying exhibits. So let's go ahead and identify them clearly on the record, how you've marked them and what they are.
Your Honor, a composite exhibit 1 are media articles about this case that involve the conflict issue with the district attorney. I think both of us plan to present those, but I've certainly prepared. That's exhibits 1A through 1F. And I don't believe there's any opposition to that.
There's no objection from the state.
Admitted.
All right. Your Honor, exhibit 2 is the transcript of the Cobb County Magistrate Court hearing where Mr. Evans called in and explained how this case down here got moved so quickly when the cases in Cobb County were not. That's exhibit 2.
Yeah, we just calling all defense exhibits by exhibits, or this, that's what I'm asking. This is Brian exhibit 1, Brian exhibit 2,
That's
Brian
fine.
exhibit 3, and I'm going to ask the remaining defendants, Gregory McMichael 1, Travis McMichael 1, States 1. We'll be able to clearly identify.
Now, we do have some joint motions with joint exhibits, so we'll name them
I
appropriately.
just want it just as clear as we can so you have the records.
No objection to Brian Exhibit 2.
And then
Your Honor, we are tendering Brian Exhibit 3, which are social media posts made by Flynn Brody, mostly while he was a candidate for district attorney. That is a composite exhibit 3A through 3N. 3N is a screenshot of the virtual town hall video I'll discuss in a second, but we're tendering 3A, and I believe the state has an objection to that.
Yes, Your Honor, the state would object on relevancy grounds to all of this. These are just literally screenshots of social media by Flynn Brody and have absolutely no relevance to this case. Most of them appear to just attempt to ensure that everyone knows he's a Democrat and that he basically advocated voting, and he advocated voting for President Biden. And that is all that is here, with the exception of, I believe, 2 posts that point the person looking at it to additional outside stories, such as 11 Alive, about this particular case. But that's all that's here. And that is Defendant Brian's 3L on February 22nd of this year at 9:45 p.m. Mr. Brody posted about an 11 Alive news story about this case, just directing people to take a look at it. In addition, on May 9th of 2020, at the time he was a candidate, Mr. Brody posted to a Top Buzz article from Savannah, Georgia, that referenced this case. And that is all that's in here that is referencing this case in any manner whatsoever. So we ask you to not allow this in. We object to it based on relevancy.
Those 3 exhibits are tendered, and Exhibit 4 is a screenshot from the webpage of Mr. Brody. I think the state is not disputing that the statements that are reflected in there were posted on the webpage, but I shouldn't speak for Ms. Donikowski.
Thank you. With regard to Brian, defense exhibit number 4, the state does not object.
3 and 4 are in.
Your Honor, we would ask that any exhibit that, of course, not admitted, be made a part of the record as our proper for purposes of appellate review. Your Honor, continue? Yes. Your Honor, Exhibit 5 would be the town hall YouTube video. The problem is that neither of us can download it. I think it would make sense for the court to review it.
How do I do that if it's not part of the record?
Well, you see, and hence my problem with Mr. Brody not being allowed to testify, because I can simply ask Mr. Brody if he made the statements that are referenced in the motion, or the state can stipulate that he made the statements referenced in the motion. But without that, I have to have testimony. So, I'm not trying to be difficult, but we would ask the court to consider. Composite 6 is Gregory McMichael documentation.
Let me address on the record, since 5 doesn't seem to exist, that it's not admitted.
Thank you, Your Honor. And Composite Exhibit 6 doesn't exist yet. It's going to be subject to whatever documents we receive pursuant to the court's ruling on the subpoena, on motion to quash, and the Grady motions.
What is 6?
Gregory McMichael documentation. Any documentation that contacts communications dealing between their office and Greg McMichael.
Okay.
The court's granted in part and denied most.
But the tender of the documents is premature, so...
Well, that's correct. I'm asking the court to leave the record open so that we can do that when we receive the information from the state.
Well, let's do it this way. If there is something that the court reviews and is produced, the court is open to a motion to reopen the record to make those exhibits part of the record.
Thank you, Your Honor. That is all the evidence. We did subpoena Mr. McMichael, but we're not going to call him as a witness. I don't know we get very far with that anyway. We rest.
Okay. I'll take the matter under advisement.
Thank you, Your Honor.
That should address all of the motions with regard to the prosecutor filed on behalf of Mr. Bryan, as well as the motions to quash.
And Your Honor, if I may ask at this time, given you granted our motion to quash, is Mr. Jesse Evans released from his subpoena?
Yes.
Thank you.
On a related matter, Your Honor, there is another motion pending before the court to preserve evidence with respect to the disqualification issue with respect to Ms. Holmes. And I think it's appropriate to address that issue with respect to Mr. Evans and Mr. Brody. The court has ruled against us, and I'm guessing how the court's going to rule, but I want to make it clear on the record that we are asking the court for an order directing Mr. Lynn Brody and Ms. Joya Holmes and Mr. Jesse Evans not to destroy any personal emails, personal texts, or other quote-unquote personal as opposed to business communications with respect to the Arbery case, specifically with respect to any issue with respect to disqualification.
The state's response is this is their personal email and their personal cell phones. And even if they're personal, they could be considered attorney work product. In addition, to ask us to respect our Brady obligations. We understand our Brady obligations, and we will go ahead and do what we're supposed to do. But this motion is not one that is on your list today and untimely, and no one is going to destroy any sort of Brady material, Your Honor, in this case.
And the court may not want to rule today, but I'm making a record on behalf of my client. We've already alleged spoliation in a website that disappeared and suddenly was back. We don't need to address that today. But we're concerned about losing evidence or evidence being destroyed, and all we're asking the court to do. And whether the court does anything or not, we've taken every step we can on behalf of Roddy Ryan to protect the evidence.
Isn't it covered really by Brady and spoliation anyway?
The problem, Your Honor, is this. If there's any gray area on what's Brady, and I think from the arguments in today's case, the state contends there's a lot of gray area, then if evidence is destroyed, it's going to become an issue as to whether it was inadvertent or unintentional or whatever. But if we can't get the order, we at least want it on the record that we contend all of that is material, and the destruction of any of that will be spoliation.
We seem to be spending part of the morning dancing in the hypothetical. I understand you're preserving the record. I'm not going to issue a ruling on that. The matters are clearly currently before the court, matters under advisement. It's Brady able to be handled under Brady, and if evidence that's material in this case has been spoliated, it needs to be brought to the court's attention. All right, the next matter that the court indicated we would get to is the motion that's filed. It was numbered 1.14, McMichael defendant's notice of intent to introduce evidence pursuant to 404B. All right, let's go ahead and address that. I think it was signed by all four counsel for the defendants. So, Mr. Sheffield, are you taking the lead on this?
That's correct, Your Honor.
Okay, your motion.
Judge, to begin on this issue, I think it would be helpful to the court to give some context and to maybe lay some framework for the court to think about this. The state has already filed their response, and I trust that the court has read the state's response. Really, the issue before the court on 404B is a three-part test that begins with relevance, 401, and then moves into 403, a balancing test about probative versus it being substantially outweighed by prejudice, and then the proof in the case that we need to make to satisfy the court that these are things that have actually happened. Would the court allow me to give a brief opening about the evidence that we're going to present, just to give it some context?
That's fine.
Okay. May I speak to the court as I move around?
Okay.
Okay.
If anybody has a problem hearing again, just let me know. Again, I understand that the goosenecks go actually to the speakers.
Your Honor, we also will be addressing at some point today the state's request to prevent the defense from going into a history of mental illness of Mr. Arbery. Some of these witnesses and what they'll be talking about, the events of what happened, have some details within them that fit within the relevance of this mental illness. So I just want to make you aware that what I'm showing the court at this moment is a timeline that we have become aware of through the exchange of discovery with the state. And the state has made us aware of several witnesses, those witnesses being in the community who may be neighbors of Mr. Arbery, those witnesses working at some of the local businesses around the community who have had interaction with Mr. Arbery, those witnesses being his mother, those witnesses being part of the Department of Community Services and Probation, and those witnesses being other officers in the community who have had cause to come into contact with Mr. Arbery. All that we are talking with the court about when it comes to 404B are other acts where that rule of evidence says other acts may be relevant if we can demonstrate 401 why we're admitting it, because we're certainly not admitting it for bad character. And so 401 says if there is another reason other than bad character, then you satisfy that part of the inquiry, and then we move into 403. So what we have learned is that Mr. Arbery, starting back in 2013 and moving through 2017, 2018, and 2019, and into 2020, had a pattern of conduct and behavior, had a pattern of other acts that included theft crimes or attempted burglary crimes, or when confronted about his actions by people who appeared to have some authority, whether it be a business owner or a neighbor or the police or the Department of Corrections or even his mom, when confronted about his act that was under question, his response to that is to get angry and aggressive, physically and verbally. And so for purposes of this part of why we're offering this, we believe that this 404B evidence will speak to several issues that are inherently locked within this case that cannot be removed from the case because they are so fundamental to the issue. So what we're speaking about, Your Honor, is the very basic facts of that Mr. Arbery was in a neighborhood on February 23rd, 2020, that he did not live in, that Mr. Arbery was in a house in that neighborhood that he does not own and had been in that house on several occasions at night over the course of several months, that Mr. Arbery is running away after being seen. And what I'm giving you, Your Honor, is the acts that are inherently part of the trial of this case. We are not limited to the elements of what's being charged, but the issues that this case involves. And so these acts that we have that are uncontroverted, being in the neighborhood, being in the house, running away after being seen, and multiple attempts to detain Mr. Arbery with either verbal commands or words, trying to engage him to detain him, and then his behavior and his reaction to that with the McMichaels, and Mr. Arbery's decision to then ultimately engage in physical assaultive conduct. These are all the issues that need to be determined and that we believe will be in the minds of the jurors. What was going on that day? Why was it going on? And what was everyone's intent? What was the motivation of these people being Mr. Arbery and the McMichaels? Because those issues are central to the case, we feel that the evidence that we'll be presenting today is original evidence that needs to be presented to aid the jury in deciding these issues. So for example, were the thoughts reasonable? I'm not sure what that is, Your Honor. I'll pause. Okay. Were the actions of the parties, Mr. Arbery and the McMichaels, were they reasonable? Were the McMichaels' interpretations of conduct and behavior of what they observed about Mr. Arbery, was that reasonable? Were they allowed under the law to detain Mr. Arbery? Why did they bring firearms? Why did they seek to arrest or perform a citizen's arrest? Why did they feel they needed to defend themselves in the process? And what the court is going to be tasked with doing, and what the jury is going to be tasked with doing, is looking at all these actions in hindsight to determine whether or not the law applies in the way that the sides will be arguing. And so that's why the evidence I'm going to present is relevant, because it's going to help to determine what was going on with Mr. Arbery that day. So if we look at 404B, we're offering the 404B evidence for Mr. Arbery to show, in this case, 404B allows us to deal with other acts that happened in the past that the McMichaels were unaware of, but that aid the jury in determining what the intent and motive of Mr. Arbery was on that day. Because his intent and his motive is something that is central to the case. And we feel the 404B evidence will help answer those questions. And just as a preliminary, I haven't asked Ms. Dunikowski her thoughts about this, but perhaps I'll say to the court, we're happy to ultimately brief this issue to Your Honor. We can argue some cases today if that would please the court, but this is something that I think we may be briefing if the court wants that. But ultimately, the law says, as we see it many times in 404B evidence against a defendant, where they bring in the past acts to show the intent or the motive or the plan or the scheme of the defendant when on trial, none of which the witnesses in the case know about, none of which the alleged victims in those cases know about, but it's brought in to inform the jury so that the jury can determine the issues that are central in the case. What we have also, Your Honor, is this other idea that not only should this be allowed for original evidence, but we also think the door has been opened essentially when we talk about the facts of the case, that the state has and the court has and the filings have and the testimony at the preliminary hearing as well as the bond motion has established that the state feels these central issues and questions are relevant to the determination of the issue as well. So, as I'll point out with this particular board, Your Honor, we have a lot of statements by state witnesses and a lot of statements by the state answering the question of why Ahmaud Arbery was in the neighborhood that day, answering the question, did the defendants commit crimes, answering the question why there was a chase. So I just say this to Your Honor, that the evidence that we're going to present today, I would like for Your Honor to consider in the context of what I'm doing this little opening for.
Understood.
Thank you, Judge. All right, so we'll call our first witness.
I made a mistake before we get to witness.
Oh, sure.
An opportunity, Ms. Dunikowski.
Thank you, Judge. Yes, please.
Okay.
Feel free to leave that up there. The state has not seen either of these exhibits, so I am going to take a moment to look at them. I wasn't given the opportunity to review these at any point in time, nor were they served on the state.
And Your Honor, just to respond, we're not admitting these in the record.
No. So just from this point forward, though, if anyone's going to use anything in the courtroom, let's make sure, at least before the proceeding starts, it doesn't necessarily need to be produced in discovery.
Sure.
If it's going to be used at a hearing, make sure the other side's seen it so that we don't have any moments of wasted time.
Very good.
Thank you, Your Honor. Based solely on the defendant's opening statement, they have failed to meet any threshold requirement for 404B evidence at all. They asserted that the 404B evidence of Ahmaud Arbery's prior crimes and other acts would speak to issues in this case. And they said that the motivation of the victim is the central issue in this case. Your Honor, they have put us on notice that this is a self-defense case. First off, in a self-defense case, you cannot start it. If you're the first aggressor, you cannot go ahead and murder somebody. You can't claim self-defense if you started it. They started this when Greg McMichael saw Ahmaud Arbery running down the street. They had no knowledge that he had been inside 220 Satilla Shores earlier, just moments earlier. They had no knowledge of that. So in order to get out of this problem they have, which is they're the first aggressors, they've got to claim they were making a citizen's arrest. Well, according to their counsel just now, they weren't making an arrest. They were seeking to detain another citizen. And they said, a question is, well, he's a neighborhood he does not live. Last time I checked, this was the United States of America, and you could go anywhere you wanted. He walked into a house that was open. Yes, not his, but not theirs either. He ran away after being seen. We don't know that. We know he ran away. We know Mr. Albenze was across the street on the cell phone making a 911 call. They made multiple attempts to detain Ahmaud Arbery. That's not a citizen's arrest. That's an illegal detention. It's false imprisonment. And they want to talk about Mr. Arbery's reaction to Greg McMichael and Travis McMichael. It's common sense, fight or flight. And what Mr. Ahmaud Arbery did was he fled because he was under no legal obligation whatsoever to stop and talk to strangers who were trying to hit him with their pickup trucks and shoot him with their shotguns. They just basically said that Ahmaud Arbery's decision and his conduct is what this case is about. That is bad character evidence. That is propensity evidence. So they haven't even met the threshold in their opening statement. They then said, were Mr. Arbery's thoughts reasonable? It doesn't matter what Mr. Arbery was thinking whatsoever. Were his actions reasonable? It doesn't matter what his actions were. He was running away from these men. The defendant's interpretation of his actions, well, if they want to take the stand and talk about that, they're entitled to. They did talk about it in their statements. Once again, defense counsel just said they were trying to detain Mr. Arbery. The question of why they brought firearms has nothing to do whatsoever with any of this. They didn't know Mr. Arbery. They made a choice to go get their firearms. But Greg McMichael also made the choice not to bother to bring his cell phone. What did they feel in order to need to defend themselves? That's nothing to do with Mr. Arbery whatsoever. Their baseline is that the jury is entitled, for some reason, to determine what was going on with the victim. Not at all, not relevant. What's going on with the victim has absolutely nothing to do with the fact that he was running down a public street in the United States of America when two people decided to get guns and try and hit him with their pickup trucks, joined by Mr. Bryan, who then actually hit him with the pickup truck. They then cornered him like a rat, according to their statements, held him. So how is his prior acts that they knew nothing about relevant to any issue in this case? Because if this is a self-defense case, it's the reasonableness of their actions. If they're the first aggressors, they have a problem. So now it's, well, was it reasonable for us to do a citizen's arrest? They weren't making a citizen's arrest. According to their own counsel, they were seeking to detain, falsely imprison, another American unlawfully. The jury does not need any of this in order to answer any of these questions. And to claim that the state feels something, I appreciate all the defense attorneys speaking for me today, but no, the state does not feel that these are essential questions. The state is going to put up its case, the state is going to prove him guilty beyond a reasonable doubt, and none of these 404B other acts by Mr. Ahmaud Arbery are relevant to that. Thank you.
All right. Mr. Sheffield, your hands.
Yes, thank you. Call Chief Rod Ellington. Dallas, excuse me.
Are you keeping that up for the witness?
I'm keeping it up for me, and so that I can keep the timeline relevant to the court.
State would object.
What's the objection?
Well, your witness is looking at your board to track whatever's going on. So, I mean, I don't have any problem you referring to it, if you just turn it over to the witness. So I know that the witness isn't testifying on things that may be contained.
Sure. You should have taken it down.
Do you solemnly swear or affirm the testimony you shall give to the court shall be the truth, the whole truth, and nothing but the truth, so help you God?
I did. Go ahead.
Chief Ellis, I'm Jason Sheffield. Good morning. With the court's permission, if Chief Ellis would like to remove his mask, may he?
Yes. Yes, sir, thank you.
Thank you.
Thank you, Your Honor.
Chief Ellis, if you'll just give us your full name, please.
Rodney Ellis.
And where are you employed?
I'm the Chief of Police and the School Safety Coordinator for the Glenn County School District in Brunswick, Georgia.
Okay, and where were you employed back in December 3rd, 2013?
I was the Chief of Police for the school system here in Glenn County, Georgia.
Okay. I want to direct your attention back to that day in particular and an incident that I believe you were involved in. Do you recall being involved in the arrest of Mr. Ahmaud Arbery back on December 3rd, 2013?
I did.
Where did that take place?
Brunswick High School.
And what was going on at that time at the high school?
We were having a basketball game, night game, and one of my lieutenants observed a firearm in his waistband.
Okay. How many officers? I'm sorry?
Go ahead, I'm sorry.
Your complete answer was one of your lieutenants observed.
One of my lieutenants observed a firearm in the waistband of Mr. Arbery.
Where did that, now in terms of this arrest, were you there and a part and participated in Mr. Arbery's arrest?
Yes.
Okay. How many other officers were involved?
I would have to look at my notes to see exactly, but there was a number of officers that were involved. There was a number of reports that were written that night, but there was a contingent of officers there, to work in that ballgame. We generally have about 8 officers there at those games.
And did you oversee the arrest and the reports and approve all the reports in that case?
I did.
Okay. What was it that first drew the officer's attention to Mr. Arbery?
As I understand it to be, and as it's written in his report,
Objection.
I learned basically.
Objection. Hearsay.
Hey, Judge, for our purposes here, my burden is to demonstrate to the court that we have a real event that's occurred and that through preponderance, I would be able to satisfy that burden. This being the chief of police and who oversaw all the officers that night and was present. I'm simply offering this to explain to the court what happened and why decisions were made and what was observed.
All right. Of course, for the purposes of this hearing,
Yes, sir.
404B, again, with respect, depending on the court's ruling, if in fact this evidence was to be presented at trial, it would be, it may be viewed differently.
I understand, Your Honor. We would have all the witnesses to speak specifically about what they did on that evening, but we thought for purposes of this hearing only that we would present this evidence in this fashion. Okay. You may go ahead and answer the question.
Please repeat your question.
Sure.
Clerk.
What was the first thing that occurred that alerted the officers to Mr. Arbery?
I learned over the radio, via emergency radio traffic, that there was a person that had been observed having a gun in his waistband inside the ball game by one of the officers that was at one of the front entrances there.
Okay. Was anything said to Mr. Arbery about that gun in his waistband?
I learned over the radio that there was an individual that had been observed with a gun, was given his description, and was advised over the radio, I learned over the radio, that he had exited the gym and was running away.
Do you know, and I think the court has... So I think the court is going to permit you to talk about what you heard on that day to sort of simplify the presentation of this evidence to the court. So you can say that what you learned and feel free to discuss it.
Okay.
Okay? So you learned Did any of the officers say anything to Mr. Arbery when they saw the gun?
The lieutenant challenged him at the door to say, stop, I need to talk to you. And at that point in time, he ran out the door, ran away from the officer, refused to comply with the officer's command to stop. I need to talk to you. Ran out the door and ran away from multiple officers there until he got to my position where I tried to apprehend him as well.
Okay. Did any of the officers try to put their hands on him or to physically restrain him?
Yes.
And what did Mr. Arbery do as a result of that?
He resisted, he ran and swiped their hands away and ran.
Did any of the officers get injured?
One of the officers was chasing him and fell, yes.
Okay. But no other physical signs of injury or scratches or anything like that?
No.
Okay. And once he ran, did other officers join in the chase of Mr. Arbery?
Yes.
Are you aware if any other officers gave him commands to stop or that they wanted to speak to him at that time?
Yes.
Who did and what did they say?
I was more than less likely the second one who the officers that made contact with him initially, I'm certain based upon the reports told him to stop, that he made contact with, that he went past. When he got to my position, one of my now lieutenants was behind him and radioed me and gave me a description and said, that's the guy they're after that's running by your vehicle. I proceeded to give chase, roll the window down on my vehicle, began to yell at him very loudly with loud verbal commands to stop. Police, I was in a marked patrol car, SUV. I ran alongside of him. He ran parallel to my vehicle. The Old Brunswick High School where this took place in no longer exists, but there was a breezeway out in front of that school, and he was running along that breezeway.
Let me stop you there. At any point when you were giving him the commands to stop, did he stop?
No.
Okay. Continue, please.
He was running along, and I was advised he was potentially armed. And my lieutenant, who also was running behind me, had his weapon out. I screamed as loud as I could, stop, 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 fearing he was still armed, because that's what information that I had. I had, my weapon out the window, trained on him, begging him, yelling, stop, stop, stop. And as he ran, he slowed down, he made eye contact with me. He began to pat his waistband. And
when he did that, what were your thoughts?
Lord, please don't let me have to shoot this man. And the elements were certainly there to have used deadly force in that situation. I was praying I would not have to. He came up empty-handed. As he was patting his waistband, he didn't have anything in his hands. The lighting was not very good there. But when he come up with his hands, he kind of made eye contact with me again. At that point in time, he began to run again, accelerating away. So at that point in time, he went around the corner, and I continued to pursue him.
Ultimately, did he stop?
He stopped when he ran around a corner away from me. He was running from me, and he ran right straight into two of my officers who took him into custody. And then I exited my vehicle, and we all three of us got him handcuffed.
Did they report to you how he stopped at that moment and took him into custody? Did he comply?
They took him into custody at gunpoint.
They did. Did they have any physical altercation?
He didn't fight at that point in time. He gave up.
He relented and
yes,
stopped.
He did not resist at that point in time.
Did you observe anything about him that you thought, under the circumstances, was abnormal?
Well, other than bringing a gun to a high school event, that certainly was unlawful and abnormal, causing us great concern as to why that took place. Knowing I was in a marked patrol car, yelling at him, please to stop, screaming at him, at the top of my lungs, as best I could to tell him to stop. And he would refuse to comply with those commands. And what the scary part of that for me was reaching for the waistband.
I understand. He was ultimately arrested?
Yes.
For what?
He was arrested for carrying a weapon on school property and disrupting, because we had to lock down the event. We had to actually lock down the gymnasium, as that was going on, which caused a disruption there. The game continued, but certainly it caused a buzz there. amongst the participants and a great deal of anxiety amongst the people that were there. He was also charged with that. He was also charged with resisting lawful law enforcement officer with violence.
It'd be obstruction.
That's correct, obstruction of violence.
At the time when he was being arrested, when the officers and he had stopped running, did he say anything at that time?
We asked him, where's the gun? Because at that point in time, we patted him down and couldn't find the gun. He said, I don't know, I must have dropped it.
Okay. And did he say anything else about why he ran?
He did.
Did he do anything at that moment or behave in any way that you thought was abnormal in terms of connecting with you and talking with you?
Not really at that point in time. He had resigned himself. He appeared to me to resign himself to the fact that he was apprehended and there was no point in resisting or running or anything at that point.
Do you know whether or not he ultimately resolved his case with a guilty plea?
He did, and I'm not sure of the outcome spent several years ago. I knew there was a plea bargain in the case. I'm not sure exactly how it was adjudicated.
Okay.
I do know I don't recall ever going to a court hearing on it.
All right. One moment, please. No further questions.
Mr. Okowski.
Thank you, Judge. Morning, Chief Ellis. How are you?
Good morning. How are you, ma'am?
Good, thanks. So you said you were in a marked patrol car, is that right?
That is accurate.
All right. And how were you dressed at that time?
I was in a Class B uniform, polo shirt, khaki pants, Glenn County School District Police. I was identifiable as a law enforcement officer.
So anybody who saw you would know that you were, in fact, and indeed, a law enforcement officer.
That is correct.
Okay. You mentioned someone running behind you. This was your lieutenant?
That's accurate.
All right. How was he dressed?
The same.
All right. So in identifiable uniform.
That's correct.
The two officers that Mr. Arbery ran into when he ran around the corner that apprehended him at gunpoint, how were they dressed?
The same.
Everybody's in law enforcement uniforms.
Yes, ma'am.
Easily identifiable.
Yes, ma'am.
As law enforcement.
That's correct.
Okay. Were there other marked patrol cars out there?
Yes.
And the person who first noted that Mr. Arbery had this firearm on him when he was going into the gym, was that also a law enforcement officer?
Yes, ma'am.
How was that law enforcement officer dressed?
The same.
And do you recall that in this case, the weapon was actually found at the front of the gym?
That is accurate.
Okay, so he dropped it right away as he ran, right?
Appears so.
Okay, because obviously he didn't have it on him when you arrested him. Is that correct?
That's accurate.
All right. And then in this particular case, he was charged with 3 counts of obstruction. Is that right? Do you remember that?
I'd have to refer to see exactly how many counts. Yes, ma'am. I don't know he was charged with that offense.
Does it sound familiar that he was charged with obstruction for Ron Harris by knocking Officer Harris to the ground? Is that correct?
Yes. Yes, ma'am. That would be an accurate statement, I would think.
Okay. Now, is Mr. Ron Harris the one who tripped over the speed bump and fell down during the chase?
Ron did fall. Yes, ma'am. I was injured. Had to be, checked out at the hospital and was on light duty for several days after that. Pretty scratched up.
Okay. And then we also have Officer David Smith, whose arm was scratched.
That's accurate.
Okay. And then we have obstruction for you by failing to comply with your lawful commands to stop running.
That's accurate.
Right. And do you recall that Mr. Arbery then pled guilty to those charges and received misdemeanor sentences on all of those obstruction charges?
Ma'am, again, that's been so many years. I knew it was adjudicated and I knew the matter was handled, but I couldn't testify to exactly what those circumstances are. I'd have to look at the record to see how that would reflect. But I knew it was handled and it was a adjudicated issue.
Okay. And I just want to make sure, this was December 3rd of 2013, is that correct?
That is accurate, yes, ma'am.
One moment. And at the time of this particular incident, to your knowledge, was Mr. Bryan, who's seated right here in the white shirt, was he present? Go ahead, stand up if it helps.
I couldn't testify if he was or not.
Okay, so you don't know him, or he wasn't part of the law enforcement contingent, was he?
No.
Okay. And do you know who Greg McMichael is?
Yes, ma'am.
All right, was he present then?
No, ma'am, not that I recall.
Okay. And his son Travis McMichael, to your knowledge, was he present?
No, ma'am, not that I recall.
I will pass witness.
Just briefly. Chief Ellis, you had said you don't recall and you couldn't remember and not look at your reports. May I approach the witness, Your Honor? Yes. I'm just going to show you this document and see if it refreshes your memory. I've showed it to opposing counsel. I'm not marking it. If you'll take a look here, she was asking you questions about.
Okay, this is the
Does that refresh,
disposition.
does that refresh your memory about the disposition of the case?
Sure.
Okay. And did he resolve that? I'm taking the document back. Did he resolve that with the felony plea of 5 years probation?
I'd have to look back at that document and see again.
Refreshes your memory.
Okay. Now pose your question to me again, please.
Yeah. You were just being asked about how he resolved it. I think the state had asked you on cross that he in fact resolved it with misdemeanor offenses, but did he resolve it with a felony plea to possession of a firearm?
According to your document, which will be the most accurate record, not my memory, but this.
Well, if it refreshes your memory.
It says that he disposition, guilty, carrying weapons in the school area.
Okay. Yeah, and just if you'll just look at it, Chief Ellis, and just see if that refreshes your memory.
Yeah.
If it does not, that's okay. If it does, then you simply contest.
Non-jury negotiated, I'm not going to read verbatim, Judge, but just 5 years sentence.
Hold on.
Can't read it out loud.
Okay, sir.
So the question I need to pose to you based on all of the
Okay.
evidence is,
Okay.
after having looked at that document, does it refresh your memory about whether or not Mr. Arbery entered a guilty plea that carried 5 years of probation for carrying a firearm?
According to this document, that's accurate.
And sir, I've noted here on this board, you did not help me create this, did you?
No, sir.
Okay, but I've noted up here that he had an arrest charge, a gun charge and obstruction back in 2013. Does that accurately reflect essentially what you're testifying here to?
Yes, sir.
Okay. Nothing further, Your Honor.
Anything else?
Briefly, Mr. Sheffield.
Oh, yes.
Yeah.
Oh, sure.
Thank you. So, is my approach right?
Good.
Using the same document that
Yes,
Mr.
ma'am.
Sheffield just showed you?
Mhm.
All right. Does this refresh your recollection on counts 3, 4, and 5, the obstruction charges, that Mr. Arbery pled guilty to a misdemeanor?
Ma'am, I don't see misdemeanor or felony anywhere on this page. I know those offenses or felonies. At least one of them is high and aggravated. The other two are felonies. I don't know what the disposition as far as if it was bargained down to a misdemeanor.
So the sentence of only 12 months as opposed to a felony which would be 1 year or above, is that an indication to you here that he only received 12 months on the obstruction charges?
On the obstruction charges, on the carrying a weapon on the school ground, it says 5 years probation.
Correct. So I'm asking about the obstruction, not about the gun charge, but about the obstruction.
It says 12 months sentence on your document there.
And you know that to be misdemeanor sentencing, correct?
I don't know that, ma'am.
Nothing further, Your Honor. Maybe excused.
Nothing.
You have anything
Nothing further.
Sorry.
Thank you, Judge.
I didn't mean to interpret your return to council table.
Thank you, Chief. You missed that.
Yes, thank you.
Mr. Sheffield,
Yes.
we can take a 5-minute recess.
Yes, sir.
Ladies and gentlemen, 5 minutes, and then we'll come back on just with top of the hour.
Okay, a 5-minute break there in a spirited beginning to the 2 days of motion hearings dealing with the death of Ahmaud Arbery, all three of the defendants in court for the first time in state courts, sitting with their lawyers at the defendant table and listening to the arguments put forth on their behalfs by their attorneys.